fall will bring more than the usual options and circumstances and issues for parents as their children return to school. Due to the pandemic, parents and students will have an unprecedented option to either remotely learn from home, have a hybrid situation where they're learning from home and from school, or in certain circumstances and occasions where they can actually go to the institution on a full-time basis. So they have options. What happens if parents disagree? And let's assume the concern is genuine. They're worried about their children's safety, their children's emotional growth, or the lack of educational experience. What are parents to do? And I'm not talking about here where parents have an ulterior motive, where they're trying to drive a wedge between themselves and the other parent, or between their child and the other parent, or they have a custody issue or a child support issue. I'm talking about strict, genuine concerns. This can happen to separated families, divorced families, and even totally intact families where everyone is living at home. What can parents do? The first option is always the best option, and what I would recommend. Parents need to talk. They need to get together. They need to reach a consensus. They need to think about what is in the best interest of their children and themselves. That's the first option. That's always the best option. But assume they disagree. Well, then the next option would probably be to seek a mediator, a collaborative law expert, or perhaps reach out to a parent coordinator or a facilitator. But the problem here is time. Time is a factor. School is around the corner. And so what can they do? Is it foreseeable that they're going to meet with one of these individuals and have meaningful dialogues and come up with a decision in a short amount of time? And even if they did, is that decision binding? Is there a legal impact to that decision? This is problematic. So what's the last resort? The last resort is always the courts. And why do I say last? Because this brings a whole series of issues to the forefront. Number one, attorney's fees. Number two, time away from their families where they're either in court or taking part in virtual hearings. Three, a court will always appoint an attorney for the children who will now meet with the children and meet with the families. And maybe the court has to wait until that individual renders their determination before it can make a decision. This is tough. This is not easy. Parents will have an option. They can bring an emergency application, either a Supreme Court or to the family court, depending on the circumstances, and get an immediate hearing on the issue. But they have to remember that when that happens, and when they use the courts, they're entrusting their fate and their children's fate in the hands of this stranger in a robe who has but a mere snapshot of their life. And that's a problem, because that person, that individual, is going to decide their fate for their foreseeable future. And generally, when people go to court and a court makes a decision, generally, one person wins and one person loses. Okay? And they're stuck with that decision. And one other thing to keep in mind before parents go to court and before they use that avenue, what will a judge do in these circumstances? I've spoken to courts, I've spoken to judges, and I've spoken to professionals in the area. The court will probably follow the local ordinance, the local city law, the state mandate. Absent exigent circumstances, that's what they're going to do. So the parents need to consider how that fits into their program, how that fits into what they want to do. So again, the first option is the best option. Try to reach a consensus, even if it's a compromise and that a parent doesn't get exactly what they want. In this way, they can still have a say in their children's future. If the courts decide, they may not.